It is March 24th, 2026, and this is the Court Gallery. And I think I've actually figured out how to use a microphone today. We'll see. Ladies and gentlemen, welcome back. Today's docket is another roller coaster. We're starting things off with a defendant who braved a literal tornado just to get Chinese food and allegedly hit a firefighter in the process. Then, let's watch as a judge's patience completely evaporates when a capital offender's vile body cam threats come back to haunt them. Finally, we close things out with a high-stakes legal showdown in front of Judge Simpson as a defense attorney aggressively grills an undercover narcotics detective to try and dismantle their search warrant. Grab some popcorn, get a drink, and buckle up, ladies and gentlemen. It all starts right now.
Good morning, everyone. Today is Wednesday, the 24th of March. Tuesday, the 24th of March. Excuse me, I don't know what day it is. 24th, but it is Tuesday. We got misdemeanor arraignments today. We've got some extra stuff, a couple of bench warrants. Looks like I may be covering a hearing at 1 o'clock this afternoon for Judge Stutzman. And we may have a prelim. So it's good to be here. I had a nice talk with Judge Pattison this morning, got here early. My secretary is back. So today, morning, Mr. George. First line isn't much of a quiz. In my mind, I've gone to Carolina. Can't you see the sunshine? Can't you just feel the moonshine? And just like a friend of mine to hit me from behind. Karen, she's the silver sun. You best walk her way and watch it shine. Watch her watch the morning come. Hey, babe, the sky's on fire. I'm dying, ain't I? That song was written in about 1969. Almost 60 years old. There's a bunch of wonderful covers of it. There's one by Glenn Campbell and Linda Ronstadt on the old Glenn Campbell show. Anyway, it's a great song. If you're from Carolina, it's probably your state anthem, where it ought to be. Arden Roy Sanger, would you come up to the podium, please? All right, Mr. Sanger, you got a ticket for failing to report an accident on March 6th. Michigan Avenue and Day Drive, not far from McDonald's, at 7:06 at night. It says drove from stop at firefighter blocking traffic during storm. Admitted to contacting him with the car. Did not report incident. Went to his resident. Firefighter did not want charges filed. Here, this was the day of the storm.
Yeah.
3/6, 7:06. The storm probably hit about 5 o'clock
in the morning.
Oh, 7:00. Well, it hit. This was 7:06 at night or 7:06?
7:06 at night.
All right, so just within an hour or so after the tornado.
It was a little bit later than that.
Well, the tornado was about 5 o'clock. So, all right. Apparently you hit a fireman who was there and then left. That's what the allegation is.
Now, he was one of their cadets.
Okay.
Who had a swelled head because he was suddenly put in charge of something. And you figure, I kept telling him, he was blocking traffic from going down Michigan Avenue. That I could understand because they didn't have on that side. But on the other side, they had power. kept telling him I wanted to go over to the Chinese, #1 Chinese food. You can't go that way. You can't go that way. I said, okay. So I backed up, started the turn. I said, I'm going over. I started my turn. Where you going? I said, over there to Quick Trip, to Quick Loop. And then he goes, when I said that, and started, as soon as I started moving, he jumps on the hood like this and says, if you hit me, I'm calling the cops. I said, go ahead. Because there was no accident, no nothing. And any damage in my car was done from.
All right, well, let's see what Mr. George, we really need people like you right in the middle of a tornado who's got to go get Chinese food. It was a disaster over there. There were trees everywhere. There were streets blocked off. The turn signals, lights didn't work. And you're out there, you got to go for Chinese. Have a seat. We'll wait for Mr. George to come back. And see what he wants to do.
It was the only place to get anything to eat. And we were without power at home.
All right, well, have a seat for a minute.
Yes, sir.
Does this guy figure out what he wanted to do?
Your Honor, so I talked to Mr. George. I went over the police report extensively, and I kind of screened him. At this time, he doesn't necessarily qualify, but I think Mr. George and I both agree. We would recommend he get set for a regular pretrial to start out with, Your Honor.
All right.
Or not guilty, please do a regular pretrial, and if there isn't, there's a potential of a different kind of resolution, Your Honor. You can always elevate the point.
The very next guy, Mr. Price, he's got a good job. I just sent him down with court-appointed counsel. Somebody's got the paperwork on that. What?
I took it down. You want me to go get it?
Yeah, I still need it.
Okay.
All right, Tim, we were talking with Mr. Arden Sanger. He got charged on a ticket with failing to report an accident, but frankly, it's kind of a screwy ticket. This was the night of the tornado, Friday, March 6th. The defendant, according to him, got in a disagreement with a firefighter. I'm not sure who it was. He says it was like a cadet. And the ticket says, drove from stop at firefighter blocking traffic during storm, admitted to contacting him with the car, did not report incident. Went to his residence. Firefighter did not want charges pressed. The accident was apparently him and the firefighter. He says the guy threw himself on the hood of his car. So I don't know, I wasn't there, but I'm not sure what the city wants to do with this one. Hi, Deputy Galarza. How are you? This is Judge Middleton. Could I see a couple of customers on Zoom? Brandy Green and Brody Jack Johnson. All right, thank you. Bye. All right, we'll do the same thing. I'm stacking you up for April 28th. Are you going to be here that day?
Somebody will be. I don't know if I have a circuit court trial set.
I'll give all these to
Give them to
TJ.
TJ.
Okay, that's a good plan. We had a visitor here last week. He was from Grand Blanc. Nice guy. He just stopped in to visit. I enjoyed talking with him, and he said he felt like he knew everybody, and he saw TJ, and he wanted to say, well, hello, TJ. Like he didn't know him from the man on the moon, but he felt like he knew him because he'd seen him before. All right, Mr. Sanger, I'm going to set this for a pre-trial. They're going to talk to the fire department and see what they want to do with this. Tim, maybe I won't go. Well, I'm not going to go that far.
If you just want a couple weeks, Your Honor.
I'll set it for. Well, the problem is I'm going to be in a different latitude. Today is the 24th, 7th. No, April 28th is what I got. Mr. Sanger, you're a few years younger than me. What kind of work did you do when you were working?
Truck driver.
Are you still working or are you retired?
I had to retire because I got pneumonia down in Denver, New Mexico, and it screwed up my lungs.
Like valley fever kind of stuff?
COPD
Hmm.
and pneumonia down there.
All right, I'm going to set a pretrial. So someone's going to be here for Mr. Sanger. Where are you from originally?
Michigan.
So it's Tuesday, April 28th, 2026 at 8:30, courtroom C for a pre-trial conference. All right, they're going to check with the officer and see what he wants them to do with this. We'll take another crack at it. I will see you on April 28th.
Okay, thank you.
Thank you. All right, I have one last no-show that I'll address, and then we'll take up our bench warrants. Brandy Michelle Green, what she got? Tim, this is your client,
Which one, Your Honor?
Brandy Michelle Green. She failed to appear for a pre-exam conference on a methamphetamine charge and a retail fraud charge. So I need to reset the pre-exam conference. Do you know when you're on duty next?
I don't. I mean, I can be here any Tuesday, Judge.
Let's see what we got here. Today is the 24th. Wow, you don't have a duty week till late May. So today would be the 24th. I guess I could set the pre-exam for the 31st.
I'll be here, Your Honor.
All right. Good morning.
Good morning.
Sorry about the mix-up. I had you brought in and then they didn't have the connection to the video. Anyway, are you
No,
Brandy
I'm
Michelle
not.
Green?
Yes, sir, I am. I'm having like a hard time seeing you guys. Seeing you. There's like a big black like box in the middle, but there we go. Now it's gone. Perfect.
All right. All right. How do I look?
You look pretty good, actually.
Okay, thanks. That's a good
You're
answer.
welcome. You're welcome.
Anyway, Miss Green, you failed to appear for a couple of court hearings. We need to get the
Yeah,
case back
so
on
what
track.
happened is I have
Well,
another court
don't
case
tell me
going-
too much about it yet at this point. Let me just tell you, let me call the cases and then we'll talk about it. Also
Okay, sure.
here is Mr. Keith Stickley. He looks really good too. He's the chief public defender.
Oh, I'm sure.
All right, the first case is 252669FY. That's a possession of methamphetamine and possession of open alcohol in a vehicle. The second charge isn't that big of a deal, but the first one is a felony punishable by up to 10 years imprisonment and a fine of up to $15,000. So
Yes, sir.
So I'm going to reset the pre-exam conference. I checked with your lawyer, Mr. George, for next Tuesday, March 31, 2026 at 8:30. And if we need a prelim, it will be April 7th, 2026 at 1 o'clock. Now, you also had a retail fraud charge in file 252398SM. You failed to appear on that same day, January 27th, and then we set a show cause and you failed to appear for that. So you issued a bench warrant for your arrest. 252398SM, show a plea of not guilty. Set a pretrial for 3/31/26 at 8:30. On $500. Now, let me ask you this. How did you get arrested last night?
I was just out in the parking lot at my apartment complex doing something with my car, and one of the Three Rivers Police Department, who has pulled me over before and I believe arrested me before, saw me out there and just simply came up and said, "Hey, Miss Green, you have warrants." And I said, "Yep, you're right, I do."
So where are you still at 40.5 North Main?
Yep. Yep, I was right outside, like in my parking lot behind my apartment building.
All right, well, you just didn't show up. That was January. It's now March. So you were just waiting for the hammer to drop?
No, so I have another case going on where I was attacked like a few months ago and like almost killed, and ever since then, like my head has been kind of fucked up.
Do you have a case in another jurisdiction?
No, in yours.
All right. Well, you never called your lawyer. You didn't
No,
show up for court. 2 months
know,
have
like I said-
passed and you're just hanging out.
I know, like I said, that other case has really kind of messed me up a little bit.
All right. Well, that doesn't give you a carte blanche to just
No,
not
it
show
doesn't. I know
up.
it doesn't. I
So
really
the
need to take care of
bond
this.
in the felony case was $500 PR. Now it's $5,000 cash or surety.
Oh,
The bond in the retail fraud was a PR bond, and now it's $500 cash or surety.
so what does that mean exactly?
Means one bond, you got to pay a bondsman for a $5,000 cash or surety bond, or sit until next Tuesday when we have a hearing on your cases. But that isn't good. You got a felony methamphetamine charge in August. You get a retail fraud charge in October. You got arrested on January 13th on both of these. You pled not guilty. We appointed a lawyer, set it for a hearing. You didn't show up for either hearing. You never called your lawyer. So
I
we're
know.
going to get you a lawyer. He's gonna come out to the jail and see you. But we'll get these cases on track next Tuesday, March 31 at 8:30. All right, you're good to go.
Okay,
I'll see you then.
so what do I need to bond out?
You need a bonding company to post a $5,000 bond and a $500 bond.
So how much do I need down?
I can't answer that. Probably
Thank you.
at least, I don't know. It depends on the bonding company. Generally, at least 10% of the bond.
So about 500?
Yes. All right. Apparently she wasn't too worried about it. She didn't go anywhere. She just didn't show up. All right, we're good with this defendant. If you'd bring in Brody Jack Johnson. Well, this is a humdinger. He's got 3 different lawyers. Mr. Johnson has Rhonda Ives in one case, Paul Gibson in another case, and Ross Truckee in another case.
And we'll evaluate, see if we can.
And Rhonda is about to leave her honeymoon, or she's about to get married, and I think she's going to be unavailable during some of these times. Good morning, Mr. Johnson. This is Judge Middleton. I'm here with Mr. Stickley, the Chief Public Defender, and we need to get your cases back on track. There's 3 cases that you failed to appear on, and we're going to get them back on the schedule. The first one is file 26113FY. You're charged with possession of methamphetamine as a habitual offender. You failed to appear for your pre-exam conference on February 10th. So in file 26113FY, we're going to set a pre-exam conference for next Tuesday, 3/31/26 at 8:30, and a preliminary examination if needed for April 7th at 1. Your bond was $75,000 cash or surety. You had posted it. How did you get arrested last night?
I was riding a bike down the road.
In what town?
There's
You're like the last lady. You just didn't show up. The bond in that case was $7,500 cash or surety. Bond is now $15,000 cash or surety. You failed to report in several cases. You failed to register for pretrial services. You have $1,305 worth of unpaid fines and costs, and you're on a payment plan where you don't make any payment. You didn't show up for court on 3 separate cases, and you're just hanging around waiting to get arrested. Are you still at 917 South Main?
yes.
All right. Now, the next matter is an assault and battery with Mr. Gibson. That's 252126. You missed a final pretrial in that case. So I'm going to set a last pretrial in 252126 SM A and B for April 2nd. at 2:00. Bond was $500 cash or surety. Is now $1,000 cash or surety. And you also had a larceny less than $200 that you failed to appear on a different date. So I'm going to set last pretrial in that case 252083 SM. Larceny. $200. I'll let you go back to bed here in a minute. Larceny under 200. Bond in that one is $1,000 cash or surety. So you're probably going to be in jail. We'll come, your lawyer, you have 3 separate lawyers. The lawyer on the felony case is Rhonda Ives. She may have a problem with that date. So I want to ask you, what the heck were you doing? But your lawyers aren't here. But you just didn't show up and just waited around till they picked you up, which is emblematic of a methamphetamine addiction. You just don't care. So we're going to give you a little clean time. Hope you get some sleep, get your head on straight. I will see you next Tuesday at 8:30 on the felony case. I will see you April 2nd on both misdemeanor cases. All right, Mr. Johnson, your lawyers will be coming out to the jail to see you. If you do post bond, all the same bond conditions are in effect, but you haven't complied with them because you didn't report for pretrial services and any of this stuff. Anyway, you're at a low point. We'll let you get cleaned up and we'll see you next Tuesday. All right, Mr. Brody Jack Johnson has a lot going on. So did Miss Green. All right, everybody can listen to Caroline in My Mind this morning for a little shared moment of humanity. It's a song I really like. It's in my head. I can almost recite the words from memory. Call the case. This matter is entitled People of the State of Michigan versus William E. Benz. File number is 2425114FC. This is a 45th Circuit Court matter. Mr. Benz started this journey in the district court several years ago in front of Judge Pattison, and the matter was bound over to circuit court on a waiver charge, on a waiver of preliminary examination. My name is Judge Jeffrey Middleton. I'm here by special assignment on behalf of Judge Paul Stutzman. Mr. Stutzman, Judge Stutzman has announced that he is undergoing a course of cancer treatment, hopes to complete the treatment and return to full service, but for the time being, we will be filling in for these kinds of things. I am cross-sworn, all 4 of us are cross-sworn to handle assignments for one another, and several times a year I'm called upon to do a circuit court matter. So you have me. What we have here is a motion by the people to revoke bond in this case. The people are represented by Elish Gallagher. Am I saying that correctly?
Elish Gallagher, Your Honor.
Elish?
Elish, yes.
Elisha. All right. Elisha Gallagher is here from the Attorney General's office. Luke Knopfinger is here on behalf of the defendant and Ross Truckee as co-counsel in this matter. This matter was assigned to the Attorney General's office during Prosecutor Marvin's term. He asked the Attorney General for assistance in multiple criminal sexual conduct cases, maybe 6. This is one of those. It precedes Prosecutor Davis's tenure, but plaintiff people are represented by the Attorney General. Mr. Benz was originally charged in the district court file number 231412. Charges are serious. It's alleged that he did engage in sexual penetration with a child under 13 years of age, 2 counts. That is a felony punishable by up to life imprisonment. He was also charged a 3rd count and a 4th count. And he was also charged as a 4th habitual felony offender, requiring a mandatory 25-year sentence if the defendant were convicted of any of these counts. The matter was bound over in 2024, I think, in front of Judge Pattison. And the matter, it's embarrassing to me, frankly, that this case is a 2023 case and we're here in 2026 and it's still pending, but I don't have any control over that. All right, Mr. Benz, you okay?
No.
Well, I got the Kleenexes there. Yeah, serious charges, serious ramifications of a conviction. The prosecutor, through the Attorney General's office, has moved to revoke your bond. And they filed a pleading with a number of exhibits attached. Ms. Gallagher, I've probably known Mr. Benz myself for 20 years or more.
I got, my wife is right there, that's who the.
All right,
That was on.
that's a good. All right, so why don't you state for the record the people's reasons for requesting to cancel the bond?
Thank you, Your Honor. For the record, and I did lay out some of it in my motion, but specifically, and I guess most troubling to me is that when defendant was on bond, he was being monitored by a tether. This was after multiple times that his bond had been revoked. There was a period of absconding, and that's laid out in the people's motion. However, this charge on November 26th of 2025 in Kalamazoo County was for violence against a female, an intimate partner. They did charge a domestic violence 3rd case on this case. Due to committing violence against a significant partner, he was able to get out of the tether. And then when he was released, never again was subject to tether monitoring. Your Honor, interestingly, when we look at
so what you mean is he went into custody and they took the tether off while he was in custody in Kalamazoo County. Is that correct?
Yeah.
Correct.
Okay.
And let him leave Kalamazoo County without putting the tether back on, with the understanding he was going to get the tether put back on, and never did.
All right, well, let me stop you for a minute, just for the record. Did the Kalamazoo County case result in a conviction?
It did not, Your Honor. From lack of participation, they decided to follow the victim's wishes. However, I did notice in my other acts notice, and I did get the video surveillance and body cams that I've shared with defense from Kalamazoo County, and some of the assaults of nature that was on video from that domestic violence 3rd charge. That did not result in a conviction.
Okay, go ahead.
Thank you, Your Honor. Notably, in the report from pretrial supervision, it says that when he was on the device, there were no violations. However, respectfully, I would think that, you know, the assault of charge would be a violation of bond, which he apparently did while on the tether. So it does not seem that the tether was enough to stop any kind of assault of behavior with significant others. Further, Your Honor, the defendant's history of not only failing to appear, but also his history with drug use and documented convictions for aggravated assault, assault and batteries, attempt, resisting and obstructing, a slew of disturbing the peace, but more importantly, or more troubling, multiple dismissed domestic violence cases, and also 2 that remain a conviction, pled down from a strangulation case. As Your Honor is aware, this is a very serious crime, and being on any type of bond and in the community is a privilege with regards to when you are charged with a criminal sexual conduct in the 1st degree. I believe that this defendant has shown that he is not able to be in the community with any kind of supervision that would protect the public and adequately assure that he is appearing for court. Further, not only was the tether not placed back on, but the pretrial service report indicates multiple attempts of contact were made and no phone calls were returned. He had not been even checking in as required. And then we did get an updated report that said on 3/4 of 2026, he stated he didn't have a working phone and is homeless. It's not setting up ideal situations. If he can't, remain on tether and have the rest of the public safe, I just think it's not appropriate at this point. And we'd ask for his bond to be canceled. Thank you.
Are you referring to the report from our community corrections coordinator, Tiffany Howe? From earlier this month in March, is that correct?
There was one from report dated March 6th of 2026, Your Honor. There was also one dated report January 28th of 2026. I believe I attached the January report as exhibit 2 to my bond motion.
Well, the more recent one you referred to, March 6th.
Yes.
Is, doesn't say who authored it, but Tiffany Howe. Where you indicated he did contact the office on Wednesday, March 4th. He does not currently have a working phone and is homeless. He's been staying at the shelter. All right, thank you. That's, I think, in the file as an exhibit. Who's going to speak on behalf of Mr. Benz?
I can make a couple comments, Judge, and then ask Mr. Truckee to maybe play cleanup here. A couple things is the case was dismissed in Kalamazoo. Just yesterday, the day before, I did receive a lot of body cam footage. I didn't have the surveillance footage to review repeatedly throughout the case. And, this is kind of awkward relitigating maybe a domestic violence that was dismissed, but Mr. Ben's very clear. He says he was assaulted first and it was in response to that. Haven't had an opportunity to review that surveillance footage. He did spend 30 days in jail because of that case. Kind of interestingly too, I note too that Tiffany Howe does say that the electronic monitoring, I guess there's some attempt to have him placed back on the GPS monitoring. But then at the end of her report, she said it is not considered best practice to maintain an individual on GPS monitoring for an extended period of this length, absent violations or new concerns. I guess maybe that's the violation of the new concern. I don't know. This case has been pending for some time. There was just a 768 notice that we're preparing an objection to filed just recently. I would note, and I think this is important because MCR 6.106 is invoked here, that due to the nature of the charges, the court can deny bond if the presumption is great. That's important, Judge, because, and I don't know how much the court is familiar with the case. I assume there's an affidavit.
That's all I do know about it. I didn't handle the case at the district court level. Judge Pattison did, but I have looked at the affidavit of probable cause that accompanies the pleading.
And I would note a couple things in there, Judge. This is a delayed disclosure from 2023 based on allegations in 2015 and 2016. So there are a lot of things going on here. There's a couple protective orders in place. So there are some medical records and some other things I can't really share with the court, but we're litigating those points. So I think what the court would have to find is that the presumption of guilt is great, and then the court would then have to make a finding that the second part of that court rule that either there would be a risk of harm to another individual or the public at large. There was a period of time where Mr. Benz was not making, that he had failed to appear. There have been a litany of status conference, motion hearings, and other things where he has appeared for those things.
I tried to follow the history of this case, and like I said, I'm embarrassed how old this is, but there have been probably more than a dozen court hearings in this matter.
Yeah, that's true, Judge. And underlying all of this too, Judge, is just, well, simple and honest in poverty, right? Where there is someone is living at the homeless shelter, struggling to find secured housing. There have been a long list of phone numbers that have been provided and then been discontinued. So Mr. Benz is here today. He has appeared at numerous court hearings. And there is a difference between, there was a bond that was set. Many of the things stated in the bond motion too were known when the bond was set initially. He was able to post that bond, and now the ask, Judge, is to just throw it out altogether and cancel the bond. Court has a wide range of options before it. I think asking to have the bond canceled is somewhat of an extreme ask given the circumstances. So defer to my colleague. Thank you.
All right, Mr. Truckey's quite eloquent. Let's hear from him too.
Thank you, Your Honor. In response to the state's argument, first, there's a hint that bond is a privilege, and I would object to that consideration. Remaining on bond may be a privilege, but it's also a right that our founding fathers established for us. Mr. Benz posted a bond, and he has attended the vast majority of the court dates. There was an issue in November, I believe. Judge Stutzman heard about that at a status conference earlier this year, and he made his determination on that at that time. This domestic violence investigation was also known at that time. A formal motion, I don't believe, was brought before Judge Stutzman, but this was all in the air at the last status conference. It wasn't a big surprise. And Judge Stutzman allowed Mr. Benz to continue on bond. He's been participating in Ministries with Communities in Kalamazoo. That is a resource he's used to stay in contact with me. He's been in regular contact with me. He's not absconded from the state. He's not disappeared. He wants to continue to litigate this case. It's a complex case with old allegations and again, as Mr. Knopfsinger alluded to, very technical and private details that we may be subject to a protective order. But all we're asking is that Mr. Benz continues doing what Mr. Benz is doing while this case is prosecuted. The domestic violence case was dismissed by the prosecutor in that jurisdiction. I don't have documents saying why. I don't have a declination. I don't have a nollie pros order in front of me. The prosecutor in that jurisdiction elected not to pursue charges after Mr. Benz did spend some time behind bars. Of note, the alleged victim in that matter was also taken into custody on that day and released shortly thereafter. She's here today. Also, there's some conflation. There's a criminal sexual conduct charge against a minor, and I don't want the conflation of between domestic violence charges with intimate partners to kind of bleed over. Those crimes, I suppose they rhyme with each other a little bit, but they're not the same. And so I want the court to make sure to kind of consider them distinctly. But with the age of this case, and frankly, with some of the matters going on in the circuit court, there's a concern I have that this may be victim of delay for reasons outside of any of our control. And I would hate to see Mr. Benz spending a prolonged period in custody awaiting his trial. So that's my piece. I'd ask that you deny the motion. If the court would want to impose further conditions, including electronic monitoring, that's understandable. Mr. Benz is employed, so he does have positive people that are in his life as well, besides just the folks at the drop. But we'd ask the court to consider those options short of revoking his bond and taking that extreme step of remanding into custody. Thank you.
Mr. Benz, where are you employed?
Through Open Door Construction.
Which is through the homeless shelter?
No, actually, I went out when I first came to Kalamazoo. I went through a temp service and I met a guy that does construction. He has his own business. Just starting out, I helped build the courthouse in Kalamazoo, and I helped build the Raising Cane out on Westmead. He's a commercial contractor. I've been with him. He's actually been with me through this whole thing. I mean, he's been awesome. Been good. Been with my boss.
Then why are you in the homeless shelter?
Just because of the traveling, I don't have a car. I can't. My boss picks me up for work every morning, so I'm just trying to get up on my feet, and with the allegations that are put on me, it's kind of hard when they want to run my background.
If I gave you a drug test right now, this minute, what would it tell me?
Probably for weed.
Yeah, for meth?
You said for weed, right?
Just weed. Possibly,
All right.
but I really, that ain't nothing that I have in my.
That's a underlying theme here. Pink elephant in the room. You've been struggling with methamphetamine for a while. Now, this crime allegedly occurred between 2014 and 2016. You've been here multiple times between then and now.
I'm not trying to do anything.
In 2023, I handled file 23653FY, and it was a very unpleasant domestic assault. I believe it was charged as domestic violence. Third offense, it was reduced to a domestic violence, 2 counts. You assaulted your partner, Ms. Yoder, and holding her down on the bed, slapping her repeatedly, tearing her clothes off, shoving her down the exterior steps. I gave you 60 days jail in May of 2023. In 2022 to 2023, the interesting thing is you just got out of jail and filed 23419FY. You were charged with possession of methamphetamine and some motor vehicle offenses. Pled to use of methamphetamine. I gave you a huge gift. 13 days credit, 13 days lay out of jail. You were to pay your fines by August 1st, which you paid 0 of. When it came time to posting a $15,000 bond, you had money. When it came time to paying your court fines and costs, you don't do so good. You have $2,059.32 worth of unpaid fines and costs. That methamphetamine case that I gave you a break on, you paid none. Malicious destruction of a building, $497. Careless use of a snowmobile, I remember that one, $192, and a bunch of traffic stuff. So, all right, I let you out in March. In April, you beat up Miss Yoder and you go to jail for 60 days. In May of 2023, I think you got out sometime in June. Then this case was charged in July of 2023 is when the trooper signed it. So I'm not sure exactly when you got arrested. Although let's take a look at that. I have the bond. So you went to jail in March. You went to jail in April, and then you got arrested on this in July, I think.
The instant case arrest would have been in late November, early December of
24. I'm looking for the bond form. I had it. The defendant had failed to appear a couple of times. Frankly, I was surprised that he posted the $15,000 bond. It was set by Magistrate Autumn Kiefer, and the defendant did post it. Then it got revoked maybe twice. I had the bond.
I'm doing better now than I was.
You're not doing better, Mr. Benz. I suspect if I gave you a drug test right now, it would show positive for methamphetamine, and you acknowledge it would be positive for marijuana. You got some indeterminate job and you're living in the homeless shelter. This is not a matter of ensuring that you show up for court. It's a matter of protection of the public.
I'm not trying to harm anybody. Just the message that I had.
All right, well, just, your lawyers don't want you to just say things at random. Here's the bond. All right, it was set the amount of $15,000 cash or surety. And it has a number of conditions which are on every bond, and they added some. The conditions of your bond are as follows. These are printed right on the back. Make reports to the court agency as specified by the court or the agency, which would include we don't normally eat or drink while we're in court, so I'd ask you to leave the coffee set aside. We'll pretend like we're in a real hearing. Make reports to a court agency as specified by the court or the agency, which that would include the reporting to community corrections, which right now is off the rails. Not use alcohol or illicitly use any controlled substance. Participate in a substance abuse testing and monitoring program. That was not ordered, but if it was, they ordered 2, 5, 8, and 9. So not use any drugs, comply with the restrictions on personal association of place, residence, or place of employment, not to have any contact with the complaining witness. Condition 8, continue to seek employment. Condition 9, continue to begin educational employments. The bond also says you shall not harass, intimidate, beat, molest, wound, stalk, or threaten to engage any conduct that would place any of the people in danger, specifically those people. This is the terms and conditions of the community corrections supervision. I will personally appear for any examination, arraignment, trial, or sentencing. Will appear at such times and places as may be directed by the district court or the circuit court. If I am represented by an attorney in this case, any notice to appear may be given by my attorney in place of personal notice to me. I will abide by any judgment entered in this case and will surrender myself to serve any sentence imposed. I will not leave the state of Michigan without permission of the court having jurisdiction over my case if I am on a felony bond. I will not commit any crime while released. I shall immediately notify in writing the court having jurisdiction over my case of any change in my address or telephone number. I will abide by any other conditions described in the face of this form. I understand if I violate conditions 12 or 13, I am subject to arrest without a warrant and may have my bond forfeited or revoked and new conditions of release imposed. Now, the conditions 12 and 13 are not assault, harass, intimidate, beat, molest, wound, or threaten any named person or persons on the face of the bond. And 14 is satisfy any injunctive order. Now, the person that you allegedly molested, beat, or wounded was not a person named in the complaint. But I understand that if I violate any of the terms and conditions of this bond, I will waive extradition. if I'm arrested in another state. So you got arrested for a domestic assault. I wasn't clear if the Kalamazoo charge was a felony or a misdemeanor. You do have several previous assaultive charges here, including the one I gave you 60 days for, which I frankly thought that was a gift. Then just before that, I'd given you 13 days, which was a gift. The statute referred to, or the court rule, which is 6.106, it deals with pretrial release. Now, one of the issues here, this is a serious charge. This is a capital offense, 4 counts of criminal sexual conduct, first degree, which is punishable by up to life imprisonment. It's not breaking into somebody's shed in the backyard. It is a capital offense as a 4th habitual offender. So you take into account the actual nature of the charge. 6.106B (1) B. A defendant charged with criminal sexual conduct in the first degree, which is this, armed robbery or kidnapping, if the court finds that proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person. I don't think you're likely to flee, but I'm not sure I've got clear and convincing evidence that you're not going to be a danger to any other person. Just before you got arrested for this, you seriously beat up your previous girlfriend. And I gave you 60 days in jail. A while later in the same year, you got arrested for this charge. It is true that you have not been convicted of the assault charge in Kalamazoo. To be convicted of that charge, it requires proof beyond a reasonable doubt. And for reasons that probably were apparent to Kalamazoo County, sounds like they had lack of cooperation. They dismissed the case after 30 days in jail. The victim was Catherine Gartner, also known as Catherine Louise Gartner. Is that you?
Yes, sir.
Or you refer to her as your wife. You're not married.
No, no.
All right. She apparently isn't very concerned about it, but what you told the officers was on the body camera, you think I assaulted someone today, just wait till I get out. I'm gonna get out tomorrow on this bullshit charge, and I'm gonna be back on the streets tomorrow, and I got something for your bitch ass. I got something for Catherine when I get out tomorrow. I got something for you, you nigger bitch. I'm not convinced by clear and convincing evidence that you're not a danger to other people. I'm embarrassed that you got arrested for a serious domestic assault charge in Kalamazoo while you've been on bond on this case for 2 years, 3 years here in St. Joseph County. I also haven't made a finding that you're positive for drugs. You've acknowledged marijuana, which is lawful for adults for recreational purposes, but I think marijuana is still in the equation. You also failed to re-register and advise the court of your address after you got out of jail. You're not presently on any tether supervision. We don't know what you're doing. You're not being drug tested, and you're living in a homeless shelter in Kalamazoo. And you talk that way to a police officer in Kalamazoo, threatening him, a complaining witness, and not comporting yourself very well while you're on our bond on a criminal sexual conduct charge. Mr. Benz, I won't be the judge to try this case. I'm not sure who will be. I'm not sure if I'll live long enough to see this case go to trial, but I'm canceling your bond. You're out on a capital offense as a fourth habitual offender. You're not in compliance with your tether requirements. You've got $2,000+ of unpaid fines and costs for previous assaultive and drug offenses here in my court. And you talk like that to the police officers.
I was just angry.
Yes, don't. You're going to jail. Your bond's canceled. A circuit judge can review it for further hearings. And I do apologize because this case is a long way from getting tried.
I would never touch my cheek.
All right, well, the fact that you'll never touch what did you say, any children? I don't know what you said, but don't say anything else. Take him back into custody. His bond is canceled.
I love you, babe.
Judge Middleton, this is set for trial
No,
on April 28th.
say that again.
This is set for trial on April 28th and it's the first
All right,
case.
okay. All right, that's Jill Ross from the circuit court. The matter is set for trial for April 28th. So we are really not talking about that.
Billy, I got you here. I love you, sweetheart. Don't worry, Billy. We'll figure it out.
For the reasons stated on the record, the bond is canceled. I feel better knowing there's an April 28th trial date. I don't think he's a flight risk, but I'm not convinced that he's not a danger to other members of the public. All right, thank you. We'll prepare the order here by the court.
Appreciate it, Your Honor. Thank you.
Okay, so we're ready on LVNV. This is case number 2406756 GC LVNV Funding LLC versus Anna Cook.
Good morning, ma'am.
Okay. First of all, ma'am, hold on. Counsel's appearance for the record.
Morning, Your Honor. Michael Stein, here on behalf of LVNV Funding.
Okay, ma'am, and what's your name?
It's Anna Cook. Good morning.
Good morning. All right, and so we have counsel here, and today is the date set for, let's see what we do last time. An objection to garnishment. Okay. Oh, last time we were here, I don't think it was on this. So I'm just gonna stick my neck out and ask, have you had a chance to talk to her about any of this?
No, Your Honor.
Okay. All right, so let's see what we got here. Looks like we have a judgment. It's a pretrial judge. Installment payments. So, okay, let's see what this is. It says notice of hearing, objection to a garnishment. Let's see what kind of garnishment we got. I'm assuming we're objecting to, there's a tax garnishment from last year. It's the only thing I see.
Yes.
August the 5th, 2025.
Yeah.
That was entered on August the 8th.
Yeah, it was to a tax garnishment that they must have just, or that the tax lien was just effectuated.
Okay.
For the fact that, so it's to the, what I believe it is to the objection to the garnishment after the money is already been paid.
Okay, ma'am. So are you objecting to the tax garnishment?
Okay, can I go back a little bit? I was before you. And
You would make this a lot easier for me if you could just answer the question I need to know.
okay,
So let's start with,
okay.
are you objecting to the tax garnishment?
I think that's what it is. Yes, ma'am.
Okay, and I need to find where your objection is. Let me look for it.
Okay.
Okay, here it is. Your objection is to see attached. So you did not check off any of the recognized objections on the form. You said you attached something. And I don't see where that is, but let's see. Oh, now you've attached your GTE bill and you've attached I'm not sure what this is. Something to Whitney, I think our civil clerk. You've attached correspondence and what your monthly income is. And then you've attached a mortgage statement. And you've attached a City of Southfield Water Department bill. And then you've attached a consumer's energy bill and a cost of living adjustment. Looks like for Medicare, showing what they're going to give you. And then you've attached a letter to me about things that happened previously in the case. Okay. None of those things have much to do with whether or not the tax garnishment is valid. You cannot object to the tax garnishment based upon the fact that you can't afford it, or your income is less, or you're paying certain bills. There's only a few bases to object to garnishments, and they basically were listed on the form, and you did not check any of those grounds. So I'm not really certain why you're objecting to the tax garnishment, which appears to be based upon a valid judgment. So could you tell me exactly what's wrong with the tax garnishment?
Oh, okay. Okay, first of all, I'm blind. That's why I'm not there, and I'm 72. I came before I lost my daughter to suicide. I told you that. I came before you in August, and you, the attorney, I sent all my information in. All my granddaughter helped me do all that. Send all my information in. How much my income was. My
okay,
Social
ma'am.
Security.
Let me stop you. This is not, the garnishment has nothing to do with your income. You can't object to the garnishment based on your income. Now, if this was an installment payment order, we'd be looking at your income. The garnishment is something totally different. And there's only certain reasons that you can object to the garnishment. And I'm going to read you what those reasons are pursuant to the Michigan court rules so that you could understand basically what you can object to on a garnishment of any kind, but a tax garnishment for sure. And so it's Michigan Court Rule 3.101. And basically, under 101K, it says, K subsection 2, objections shall be based on one or more of the following. Number one, the funds are exempt from garnishment by law. You have not alleged that your funds are exempt from garnishment by law. Number two, the garnishment is barred because you have an installment payment order. You have not alleged that. And even if you did allege it, installment payment orders bar garnishments to people's work and labor, not tax garnishments. Number 3, or number 4, garnishment is precluded because the maximum amount permitted by law is already being withheld pursuant to a higher priority garnishment. You have not alleged that you got a different garnishment that's already taken the maximum amount of money. Number 5, the judgment has been paid. Well, you're not saying you already paid the judgment, so therefore you shouldn't have a tax garnishment. Number 6, the garnishment was not properly issued or is otherwise invalid. There's nothing about anything you have said that says the garnishment is invalid or that it's not properly issued. Or something on the garnishment statement, the balance on the garnishment statement, it's incorrect. Not the judgment, but what they said on the garnishment statement. They made an error on it. You have not alleged that either. Those are the only bases that you can object to a tax garnishment. So the fact that you came last time and you showed us all this income, I understand that. I understand this might be hard for you, but they have a right to collect, and the Michigan court rules give them that right to collect through a tax garnishment to the Michigan Department of Treasury. There's nothing I can do to stop that unless it fits into one of those categories that I just read. So when I asked you what is wrong with the garnishment, you started talking to me about the other things, about what you can afford and things like that, which doesn't really apply here. In this particular scenario, it might have applied to an installment payment order as to what you could afford, but not to a garnishment for taxes. So I'm not really hearing anything that I would be able to grant you your relief, which is to stop the garnishment. Counsel, did you wish to ask?
I don't.
Ma'am, would you just?
Yeah, I guess I don't understand. I have $1,000 from my property tax credit, and I was going to use that to pay my bills, to pay my lights and gas that's going to be cut off.
I understand.
And I was going to use that. When we went before the attorney the last time, you asked the attorney, did he want to install? I was willing to try to pay $5 a month, and you told me to take. The attorney said he didn't want that $5 a month, and you told me to go ahead and take that $5 and get me a snack. I have not half eaten. My bills is more than my income, so the $1,000.
I get it, ma'am. I don't want you to work. I don't want you to work yourself up.
I'm so sorry, ma'am.
Don't cry. Don't cry.
I don't even have an Easter dinner. I didn't have an Easter dinner last year, and I tried to pay that attorney $5, and you said to the attorney, and you said get you a snack, and that's what I've been doing. And I said I'm gonna take this $1,000 that I get from my tax property credit and pay my water bill, my light bill, and my gas bill, so they don't cut it off. And I talked to the Treasury office, and the Treasury office told me that they can stop that. I have to have a hearing with the judge, and that's what I did. But if you take it, that's fine. There's nothing I can do about it. I just have that. My church gave me some money to pay on my gas bill. I tried to make arrangements with that attorney, and you even said to the attorney, you don't want the $5. The attorney said no. He said no, and you said I'm going to put it on the record. So I don't know what to do with it.
I remember all of that. I remember because it was Mr. Mall that was here, and you did offer him $5, and he said he didn't want it for the installment payment. It was so little. He let you keep your money, but then I don't think that they understood the gravity of your circumstance when they filed for the tax guarantee. What you have to understand is judgment creditors, they have a lot of things, especially this particular LVNV funding. You know, they have a lot, they're a judgment creditor for tons of files. So they have things that they just do routinely. And routinely might be that they go to get a tax garnishment for every file. That there's no human face on the file. They just doing it because they have a right to do it. And I don't think they understood what your circumstance was, particularly like Mr. Mall did when he was here and said, keep the $5. We can't take that. That's no. And I understand that I don't have legal grounds to stop this garnishment. I just don't. I wish I did, because I would, because it's terrible when you can't pay anything and you're disabled and you're blind and you're trying to take the little income tax money that you get, $1,000 to pay your bills, and you're borrowing from your church. The only thing I can do is counsel now has heard all of this, is to tell him to take it back to his client and see if they'll just release the tax garnishment. They can do that if they choose to do that, and they can mark you uncollectible for at least right now.
I would happily put a note in there of what transpired, what the situation is.
Yeah. You hear that, ma'am? He's going to put a note in the file to let the client know that you just don't have any money. I remember this because Mr. Ma said, we don't want the $5. Please keep it. And then I think I did say, well, you know, take care of yourself and get yourself a snack or something. I probably did say that. And I think you said you did do that and you've been trying to eat.
I can't eat now. I can't eat now. I'm not eating right now. I just don't know what to do. I was going to take that $1,000 and pay my gas bill.
Ma'am, can we help you to get some assistance somehow? If I can take your information off of our file, I can see if we can find a way to get you some assistance from. There are organizations that do give assistance. The Southfield Human Services Office does give certain kinds of assistance. I'm not sure if it will cover yours. I know that Forgotten Harvest and our police department works well with Forgotten Harvest during holiday seasons. And they put together, I know in the fall, they give out turkeys and potatoes and food so that people can have a meal. And you say you cannot have an Easter meal and you didn't have one last year. So do you mind if I kind of give your information along so that we could see if there's something we could do to help you at least get a meal? Because since we can't do too much with the garnishment, I can't, unfortunately. I wish I could, because I would certainly stop it. But I gotta have a legal grounds to do it though. So let me see. I got your phone number. I'll refer this back to a couple of people and see if they can find you some assistance. So do you have assistance with your housing payments?
I get $2,000 a month from my Social Security, and my mortgage is $1,000 a month.
Okay. Yeah, you're kind of tight there, huh? I get it.
Well, if they just take it, then there's nothing I can do about it. I just pray about it. Ain't nothing I can do about it. Then I won't have to worry about it no more. Yeah.
What's this judgment?
Was $1,200, 1207 maybe is the balance. They got, I think, 1,043. So there's just a little remainder.
And maybe if they take that, just be done and let her go.
That's what I'm gonna look at the dollar, you know, everything.
This is so sad. Okay, ma'am. So what we're gonna do, could you prepare an order just denying her objections is invalid for the tax garnishment, just a regular scale form?
File it.
Yeah. So ma'am, I'm gonna have to deny your motion, but I've got your information. And I'm gonna make a couple of calls to places just to see if there's anything we can do to help you get along. The lawyer here has said that he is going to make a note that they'll just, whatever they got, they'll just keep it and they hopefully will not try to collect any balance.
Thank you.
Okay?
Yes, ma'am.
All right. So we've got your information. Thank you so much, Ms. Cook. Bye-bye now.
Thank you. Bye.
Court does call the case of the people versus the Jacks.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Alexandria Taylor on behalf of Nikita Jackson, approaching to my right. Ms. Jackson, please state your name for the record. Nikita Jackson.
Thank you.
Your Honor, this is the day and time set for preliminary examination. The people are ready to proceed. I did have two preliminary matters. The court would be willing to address those first.
All right.
First would just be, I don't know if the defendant intends on calling any witnesses. The people have only two witnesses that we intend on calling today. I would ask for mutual sequestration to be ordered.
Objection.
Objection.
All right. Witnesses are hereby ordered to question.
Thank you. And the second issue or matter, Your Honors, I would be requesting if the court would permit to turn off the live stream camera that faces the witness box. These are law net officers that often do undercover investigations. And so for their continued safety, I would prefer if we could keep them away from the cameras as much as possible.
Understood.
No objection.
All right. We're gonna lock it.
Sir.
Excluded. All right. Very good.
Thank you. You will call Detective Kessler and I'll go get him from the side vestibule.
Hold on. What'd you say?
Camera on you first.
And then as he walks in and then we'll put, all right, very good. Sir, please come forward to be sworn.
For you, Vic, raise your right hand. Do you solemnly swear upon the testimony you about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. State your first and last name, your record, please.
Matthew Kessler, MATTHW.
All right, you may inquire.
Thank you. Good afternoon, sir. How are you doing?
Good, how are you, sir?
I'm just fine. Sir, how are you employed? In what capacity are you employed?
I'm a detective, science, Michigan State Police.
Is that commonly known as LawNet? How long have you been working with LawNet?
I went out there in January of 21, there till October, got pulled back to road for staffing, went back to LawNet in March, April of 23, been assigned since then.
How many years of law enforcement experience do you have?
I'm in my 16th year with Pittsfield Township, and I served with the city of Ypsilanti for about 2 years previously.
So 18 years total, if I'm doing that math right? All right. Have you ever investigated drug trafficking or suspected drug trafficking?
Yes.
What sort of investigations or trainings have you done on that issue?
Multiple trainings prior to going along. I was a road patrol officer and able to conduct street level kinds of big investigations and into the MSP. Many other trainings that worked with law.
I want to turn your attention to February 29th of 2024. Were you working on that day? What were you doing that day? Or what was your title at that time? And specifically on that day, what were you doing that day?
We're surveilling 40 Jackson.
Where were you conducting the surveillance?
We conducted this watch.
At any point, did you ever go to 7573 Roxbury Drive? When did you go to that location? Why did you go there? And just for clarification, do you know what city or township that address is in?
Township.
Do you know what sort of address that is? Is that home, buildings? Right. Do you know who the title owner of that property is or who owns that property?
Title holder?
Do you know who owns that property? Right. When you arrived at that address, what did you do?
We not announced our presence. Corey had been previously detained, so we president. Jackson came into the door.
Do you see Nikita Jackson in the courtroom today? Can you please identify her by an article of clothing that she's wearing?
White blouse and overcoat.
The record may reflect the witnesses identified the defendant.
Record shows so reflect without objection.
When you first made contact with the defendant, where was she?
She opened the door.
And this sort of building, can you describe sort of the layout of the building?
So when you go in the front door, there were stairs. To the right was a room, to the left was a room. And you kind of went just to the right of the stairs and took you into the living room / kitchen area.
So there's multiple stories?
It's a 2-story.
Gotcha. What did you do when you made contact with the defendant?
We advised her right here, her son, Cameron, I believe, was coming down the stairs. We asked him to go in the kitchen. Search the house for other occupants. I explained to her this while we were there.
Did you ever inform Miss Jackson of her Miranda rights? What did she say when you informed her of her rights?
She went then had a conversation.
All right. What was the nature of that conversation?
Yeah, I called her, she got her arrest, and she wanted to go. I told her about the Miranda rights. Asked her for drugs and guns in the house. Talked a little bit about her son, Corey, who was the main suspect in this investigation. We talked a little bit about how he had previously stopped over at starting this investigation.
Did you ever discuss or who all lived in the house with her, the defendant?
Yes, it was her and her 2 sons.
Did she advise who stayed in which rooms?
She told us which one was Cameron's room, which one was Corey's room, which one was her room.
So which one was the defendant's room?
If you go straight up the stairs, his was just off the left. Sorry.
Yes, Miss Jackson.
If you go up the stairs, you go right, kind of go down that gangway, for lack of better words. Then to the right is her master bedroom.
What happened once LawNet investigators made entrance into the home? What happened next in the investigation?
So once the house was secure with occupants, I stayed in the kitchen. Other detectives searched the residence. I spoke to Ms. Jackson, and I was in charge of maintaining the evidence log, collecting the evidence, and putting in evidence bags. And then after that, brought it back to the office.
Were you ever presented any items of evidentiary value by Detective Sergeant McIntosh during this search? What did Detective Sergeant McIntosh provide to you during this investigation?
Provided multiple pieces of evidence by Bill.
And how did you log those items? How do you keep track of them?
So he gives it to people, all detectives bring me. I put it in a evidence bag, evidence log that says what the item is, what room it was found in, where in the room was found it.
And specifically, did you ever have an item number 36?
Yes.
What was that item? And who provided that item to you?
Detective Sergeant.
Did you ever send that item to be tested for anything? Showing defense counsel has been marked as People's Proposed Exhibit 1. May I approach the witness?
You may.
Sir, maybe it was marked as People's Proposed Exhibit 1. You can take a look at that, and I have a copy for the court as well.
Yes.
Do you recognize this document?
Yes.
What is it?
It's the lab report from Oakland County Sheriff's Forensic Science Lab.
And looking at this report, is this a fair and accurate copy of the report that you received from that lab as it relates to this investigation?
Yes, sir.
People will move to admit what's been marked as People's Proposed Exhibit 1 into evidence.
Any objection or voir dire?
Objection for exam purposes, Your Honor.
Exhibit 1 is admitted.
So, sir, looking at this document, what on this document shows that this report relates to this defendant?
On the top is the case number and the associated individual.
And you said that you received an item 36 from Detective Sergeant McIntosh. Is that correct?
Yes, sir.
Does this document say what that item tested for?
Yes, sir.
What does it test positive, or what did it test for?
GC/MS and GC testing of one tablet revealed methamphetamine scheduled to local weight of tablets equals 0.065 grams.
You said 0.065. Are you sure that that's correct?
Unless I'm getting bold, it looks like 0.65, but 85, right?
I'll move on.
It's like a 6 to 1.
Well, I believe you said 0.065, but it's 0.65. Is that correct?
0.65.
Thank you. So you said that you've investigated narcotics and narcotics trafficking before. Is that correct? Do you know what the typical use amount is for methamphetamine?
I mean, typically there's several pills at a time. People who deal narcotics have thousands of pills, not hundreds of them.
Okay, just 1 second, please, Your Honor. Other than that item that was marked as item number 36, was there any other items of evidentiary value that you recovered as it relates to this defendant?
I had to go, but we covered multiple pieces. This was the only one that was charged with weapon. We looked in both nightstands. There was tied off baggies of pills, and this was the one that tested as a scheduled narcotic.
How many different pills did you find in the defendant's room?
I think there was probably 5 or 6 baggies. The right nightstand, and there was 4 or 5 baggies of pills, and then the left nightstand where this was located by Sergeant Manning Passion. I think it was just this baggie.
Pass the witness at this time.
Cross-examination.
Detective Kessler, prior to February 29th, 2024, had you conducted any surveillance of Mr. Curtis? Yes, Roy Curtis. In how many days? And when you were conducting that surveillance, did you put that in your search warrant affidavit?
Yes.
Okay. And your search warrant affidavit largely contains information from the initial stop that you referenced in your prior testimony, but you were not at that initial stop of Mr. Curtis, correct?
Stop that occurred before we executed the search warrant.
That's correct.
I did not stop that. I was part of the surveillance team, but I did not get out with Trooper Schreiber on the traffic stop.
Actually, I'm talking about the stop on February 10th, 2024.
That's all. That then stop is what initiated it.
And so the information that's contained in the search warrant affidavit, the first several numbers, where did you get that information? The first several numbers that reference the stop on 2/10/2024 from their report. So you
talking about the paragraphs
in your search warrant affidavit. And so the information contained in those paragraphs from the stop on February 10th, 2024, where did you get the information from that stop?
Wouldn't you have to show him what you're talking about unless he has memory of it?
That's what you're asking.
Okay, so you reviewed that search warrant affidavit? Or did you say you reviewed their report, Trooper Sass and Trooper McNish?
I authored this.
Did you watch any of the body cam footage from February 10th, 2024? Which footage, if you recall?
We saw. I watched it with Smith.
With Trooper Smith? Were you aware that Mr. Curtis had a valid CPL? If I said that was on the body cam footage, would you have any reason to disbelieve that? And so I know when the prosecutor asked you about what else was found, you said we found guns and ammo, correct? In the residence. Were the guns registered? And so in your experience as a law net officer, usually when you conduct these search warrants and you find guns and ammo, does the defendant typically have a CPL? And right, but you would agree if someone is a convicted felon, they cannot be in possession of a firearm.
By law, they can't.
Yes.
Possession of weapons.
However, that was not the case here though, correct? None of these weapons came back stolen, correct? And so in an investigation to determine whether there is in fact drug trafficking is whether someone has a CPL. Is that relevant information? Okay. So in your search warrant affidavit, you list out again the details from Trooper Sass and Trooper McNeil. Would you agree that that was the foundation of the search warrant affidavit?
Yeah. She is fine.
And did you later learn that the items that were seized from Mr. Curtis from his vehicle were in fact fake drugs, for lack of a better word? Okay.
32.
And you were gesturing towards the prosecutor, so the prosecutor informed you of that. And is that relevant information to an investigation to determine whether there's drug trafficking? So in your search warrant affidavit, you state that detectives started surveillance of Curtis, and it was yourself, Wiggins, and McCallum in DeCenzo. Did I pronounce that right? Observed Curtis at multiple strip malls. Is that correct? Okay, just sitting in his car. Is that correct? And then you put that on February 21st, 2024, that Detective McCallum observed Curtis at a Shell gas station. Is that correct?
I don't have my search warrant.
Would it refresh your recollection to look at it? Okay. And so is it anything odd about a person being at a gas station in their vehicle?
You see what gas stations, they don't get out and pump gas and they just sit there when they go and just sit in a strip mall and don't go into businesses. That is to be an odd behavior.
And let's just talk about like the gas station. Did you observe Mr. Curtis exchange any packages with anyone?
Something like you said that what the affidavit that was so I didn't
Yes, you didn't observe anything that day. So then again, on February 29th, it stated that Mr. Curtis was parked in front of 1713 Tudor Drive in Ann Arbor. So in your investigations and investigating whether there's drug trafficking, was there anything significant about that address, if you can recall? And had you previously done any investigations regarding that specific address in Ann Arbor? And then again on 2/29/2024, you reference an address 27227 Winterset Circle in the city of Farmington Hills. Again, that was you that personally observed that, correct? And as part of your investigations, was there anything previously concerning that address in Farmington Hills?
I come to the door, exchange something, then go back in, and then he left. That address was observed shortly before the traffic stop by teenage driver. Is my caution.
And was there anything recovered from that address in Farmington Hills? And so is it fair to say that the addresses that are listed in the search warrant affidavit in the locations such as the strip mall, Tudor Drive, Winterset Circle, these are not Mr. Curtis's home location, correct? And so on February 29th, 2024, when Mr. Curtis was detained, do you know if his vehicle was searched?
That is not search warrant.
And so in your prior investigations and work with LawNet, has the address of 7573 Roxbury Drive in Ypsilanti Township, has this ever been an address of interest? Okay, all right, thank you.
Can you redirect?
No, Your Honor. Thank you.
All right. Thank you, sir. Get it back on. Hang on before you step all the way down. Can you get it back on me? Now it is. Okay. Yeah, that gets. I'll take you. Thank you, sir. All right, you make all your next witness.
Full Detective Sergeant Hush.
Just come forward to be sworn.
Say, see you right hand. Down short for testimony about the shoot the whole truth and nothing but the truth. So be it. Thanks for your first and last name, correction, please.
First name is Christopher Leslie McIntosh, CHRIS, POPHER, MCI, NT, OSC.
All right, you may inquire.
Good afternoon, sir. How are you doing?
Good.
Doing just fine. Thank you for asking. Sir, how are you employed? In what capacity are you employed? How were you employed back on February 29th of 2024?
Detective Sergeant, Warrant.
How many years of law enforcement experience do you have? Going back to that February 29th date, were you ever at an address of 7573 Roxbury Drive?
Yes.
What were you doing there? And when you made your arrival at that address, what did you do? What was your role in that search warrant investigation?
Primarily the residence was there was being search residence.
All right. Did you search the residence? And can you provide the court sort of a layout of what rooms you searched in that residence?
I did a detective sweep of the base, vision, and mainly my focus was in the upstairs bedrooms.
How many bedrooms are upstairs?
I searched 2 bedrooms that were possible. Searched 2.
Which 2, using sort of the layout of the house, what 2 bedrooms did you search?
When you first walk up the stairs, straight ahead was my portrait.
Would that refresh your recollection?
Yes.
Do you have any objection?
No objection.
It's Corey's room, and then to the right, Miss Jackson.
Okay. How did you know which room was Miss Jackson's room?
It is the main room there, the largest room there. It's filled with female items, no, nothing else there. She's also around the room.
When you search, and just for the record, do you see Miss Jackson in the room here today?
Right.
Point to an identifier by an article of clothing that she's wearing.
She's sitting to your right, wearing a brown jacket.
The record may reflect this witness that identified the defendant.
Record shows so reflect without objection.
So just making sure I'm understanding. So you said that there's a room belonging to Corey, and then you said there was the defendant's room. Which side was the defendant's room on in comparison to Corey's? All right. And when you go into that room, can you describe the layout of that room? What's in there, or what was in there?
Large bedroom, large bed, both sides nightstand on the other side of the bed. There's a walk-in closet. There's also another closet across from that. Then the whole bathroom.
When you searched that room, did you discover any items of evidentiary value to your investigation?
I did a nightstand. I discovered a pistol that was sitting there.
Which nightstand? Anything else?
Filled with flat.
Did you present either of those items to Detective Kessler? Which one, if or both?
Both items.
All right.
There were other items I located with other items.
And do you remember what item number the pills were that you gave Detective Kessler?
Property item number.
No. When you were searching that room, was there any items like an ID or anything belonging to Miss Jackson? What sort of clothing was in the room?
Clothing belonging to.
All right. Were there any, was there a let me rephrase this question. I'll strike that last question. I'll just move on, actually.
Okay.
Other than those 2 items that you previously mentioned, did you find any other pills?
I don't believe I found any other pills. I found other weapons, magazines.
Still in that room or in other places of the house?
In that room, located within the parts room and the bedroom, in the walk-in closet.
How were the pills, the ones that you said were item number 36, how were those packaged?
They're a plastic bag, you know, twist off.
Okay. So not in a prescription bottle? What color were those pills? Why did you think they were items of evidentiary value?
Pills are normally located, prescription pills are normally located in a prescription bottle. These were located in- So it'd be illegal.
Ma'am, just 1 second, please.
Okay.
Pass the witness.
Cross-examination.
Detective McIntosh, prior to executing the search of the home, had you previously surveilled Mr. Curtis that evening? Was that the only time? And do you recall what you observed when you surveilled him? You don't have any recollection of it? Would it refresh your recollection if I showed you the search warrant affidavit? Okay, may I approach, Your Honor? Oh, yeah, it's one piece of weird. Detective, did that refresh your recollection? So do you recall on February 29, 2024, observing Mr. Curtis? And so in your training and experience and time that you were with LawNet, that address at Winterset Circle in the city of Farmington Hills, had you ever done any prior investigations there? Is it fair to say that the unknown male that came out of the house, you did not observe him with anything? Okay, thank you. Nothing further.
Correct?
Nothing, Your Honor.
All right. Thank you, sir. You may step down.
Thank you.
But hold on 1 second. Okay, they got it locked on me. You fine.
Your Honor, we will have no further witnesses and rest at this time.
All right. Any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, I think we'll move or bind over on the count 1 possession of methamphetamine. I believe the testimony that the court heard today was that search warrant conducted at the defendant's house, and that during the course of that warrant, 2 pills were discovered in the room, in the defendant's room. Those pills tested positive for 0.65 grams of methamphetamine. I believe there's probable cause to believe I believe people have met their burden by probable cause.
Thank you, Your Honor. Your Honor, as this court knows from the previous preliminary examination of Mr. Curtis, those pills that were found on 2/10/2024 were essentially fake. They were not controlled substances. As Detective Kessler testified as the affiant of the search warrant, that stop was largely the foundation of the search warrant. And so, Your Honor, relying on Illinois v. Gates 462 U.S. 213, Your Honor, looking at the totality of the circumstances, there simply was no probable cause. But even if we say
Probable cause to do what?
for the search warrant of the home, Your Honor, because Detective Kessler says that the 210 stop was the foundation of the search that led to the search warrant of the home on Roxbury. But Your Honor, even if the court were inclined to say, okay, despite the pills being fake, they didn't know it, maybe it was, but even looking at the affidavit and the testimony from both detectives, there still has to be a nexus. And so the case law requires that there be some nexus. And so the probable cause requirement requires a substantial basis for concluding that the search will uncover evidence wrong. So Your Honor may say, like, okay, maybe they have that. However, judges also require the fair probability that contraband or evidence of a crime will be found in the particular place searched. And so it's interested in the limited surveillance on these 2 days. It looks like 2/21/2024 and 2/29. Mr. Curtis was essentially everywhere but the Roxbury house. And so how can we say, Judge, that these weak facts can establish a nexus? I mean, that would be a slippery slope. Again, he's at the strip mall, the Shell gas station, Drive in Ann Arbor, Winterset Circle in Farmington Hills. There's absolutely no testimony on this record of any surveilling coming in and out of the house, parked in front of the house, individuals coming. We don't have that, Judge. And so I'm relying on People v. Garvin, which is 235 Mishap 90. It's a 1999 case, Judge. And there again, it states it has to be the fair probability that contraband or evidence will be found in that.
Why wouldn't a fair probability be the very fact that he lives?
Because there's no, Your Honor, looking at the case law in cases where they have found that nexus is evidence such as, again, they observe transactions where people are coming to his house and he's walking out and there's a hand-to-hand. Your Honor, everywhere that we have in the search warrant affidavit is outside, and I understand what the court is saying. Yes, he, allegedly he lives there, but there's nothing that ties the house to any sort of criminal activity. And as stated in Garvin, fewer foundational facts are needed to support a search of a motor vehicle. So that I don't disagree with. However, when it comes to a house or a home, the standard is greater. And so based upon, again, these limited interactions that were observed, and even if we think about the 220
For the cases that you're setting, drug cases?
Garvin is, Your Honor.
Go ahead.
Yes. And so even when I just questioned Detective McIntosh, even with the Farmington Hills one, it's like, yeah, an unknown male comes out the house, but it's like he testified, didn't even see him walking with anything. And so these foundational facts, again, might support a stop of the vehicle, which Mr. Curtis was stopped on 2/29/2024, but it simply fails to meet the requirement, Your Honor, for a search of the home. And so we're asking that this matter not be bound over and it be dismissed.
Sounds.
Your Honor, I want to start off by just drawing the court's attention. I believe there was an argument made that the suspected narcotics originally found in Mr. Curtis's vehicle came back as not being controlled substances. That information was not learned until well after this search warrant was already done and the house was already searched. Certainly at the time that the search warrant was done, the best information they had, and what the information they had was that the defendant's son was trafficking potential narcotics. They drafted a search warrant, the magistrate approved it, they executed that search warrant.
But even if the argument that they're fake drugs is still a crime.
Correct, Your Honor.
So, okay.
Yes. And even if the court said, I think there's an argument to be made, it's not my first limit, I think there's an argument to be made that even if the court says the search warrant wasn't valid, there's still a good faith exception to that for these officers to conduct this search. I did not hear any argument against the elements of this offense being the possession of methamphetamine. And so for reasons originally stated, I would again move this court to bind this case over to stand trial in circuit court.
Anything additional?
Nothing else, Your Honor.
All right. Yeah, well, certainly there has to be a nexus, but if I were to buy defendant's argument, that means that where officers may not see the individual go to their address, but know their investigation that the individual resides at that address, that there could never be a search warrant of person's premises. Really, typically, and I have not reviewed, and if you want me to review it, I will, that search warrant, but it leads them at least to address. There's a nexus. It's important also to understand because this incorporates part of another record. There were not just a couple pills found with the defendant's son. There was a lot of pills. And certainly there may be a reason to ask where are these coming from? Where are you keeping these outside of the trunk of this vehicle? When one is looking at probable cause. It seems to me that the defendant is challenging the search warrant itself, which I would be limited by the four corners of the search warrant. And I don't have a copy of the search warrant. Seems to me that the analysis that this court would go through is in viewing that search warrant, whether or not contained in that search warrant, once it's prior to its signing, whether or not there's probable cause to search the premises. And that's where I think you get to the good faith, that if on the face of that search warrant, there is good cause or there is probable cause and the search warrant signed, then the execution of that search warrant by the officers and what they discover, I think would be well within their rights, given all of the totality of the circumstances, that it's a good faith exception that they were going through. They were operating on what appeared to them and what was a valid warrant. But I haven't heard the defense argue before the court that the warrant itself is invalid. I don't know that that's what you're arguing to be, because you haven't really said that.
Well, I mean, that is the argument, but I was a little bit in a trick bag today because I discovered that Officer Sass was not going to be here, because the problem, Judge, is that, you know, Detective Kessler is the affiant, but largely majority of the search warrant is the 210 stop. And so Detective Kessler does not have personal knowledge of that stop outside of what he testified to, that he, you know, reviewed the report. He stated that he reviewed the body cam footage. But again, that was the crux of what the defense wanted to argue, because there are things that are in the search warrant that are contradicted.
Was Sass at the execution of the search warrant?
No, Your Honor, not to my understanding.
Then how does that put you in a trick bag?
Because, Judge, if I'm arguing that the search warrant is invalid, and if 80% of the search warrant is from Trooper Sass, I can't cross-examine.
Well, okay, I get what you're saying, but it's saying that somebody's put in a trick bag.
No, I didn't mean to imply that it was on purpose. I didn't realize
Okay.
today, you know, when I talked to the people, that he said that he was not going to be here, because I just assumed, because again, the basis of the search warrant, and that's why I questioned Detective Kessler about it, is the 210 stop. And so when all the witnesses are here and not one of them was at that stop, it's just difficult because, as I stated, there are things in the search warrant affidavit that are contradicted by the body cam footage, but the body cam footage specifically is Trooper Sass. It's his footage.
Okay, well, if you want, I don't know then. I mean, I'm not going to necessarily frame your argument, but it seems to me that if you're arguing that that the information underlying the search warrant is incorrect, then certainly I would give you an opportunity to, I mean, you can try to get Sass here. The problem becomes somebody else is relying upon that report.
Right.
They place that in a search warrant. I think I'm still then left with, if I view the search warrant and I look at the four corners of the search warrant, if there's probable cause contained within that search warrant, then the officers can act. I mean, I understand where you may want to go, but I don't know.
Right.
I don't.
No, I understand what the court is saying, because the Trooper Sass could testify and the court could still say that based upon the four corners there were probable cause, or that it was a good faith reliance upon, yes.
Right. And these officers, as I understand it, going back to, I guess, the first part of your argument, they have that report from Sass is what then causes the rest of this to occur. And they believe that based upon that report, they're then observations of the other individual that they need to and would have probable cause to search the residence.
Correct.
So I'm not, I hear you. I'm just not sure how I get there. I'm not sure Sass necessarily helps you. I also don't know that. I mean, like I said, I will review it. I'll review the four corners of the document, but I don't think it gets you to where you want me to be.
I understand.
All right. Okay. So based upon that, hearing the defendant's argument, don't, at least what's in front of the court now, see anything that is a flaw to the execution of a search warrant, nor which would lead this court to exclude the testimony or exclude the evidence that was seized at that address. The testimony in this case from the two officers indicates that they went into the bedroom, which the defendant herself identified as her bedroom. That evidence was then seized from that location. The methamphetamine was seized from there, logged in, tested, and it comes back methamphetamine. Court believes, based on that testimony, that people have sustained their burden in showing that there's probable cause to believe that this individual did commit this offense. And so therefore I would bind the defendant over on count one, on a single count. As to the arraignment, you
Stand mute and move a formal reading, Judge.
defendant and waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
19th at 1:30 with Judge Punky.
May 19th, 2026, 1:30 before Judge Koki. Bond will continue. Thank you.
And the information.
Yes, if we got one in there, I think we do. Is that it for the day?
Yes, Judge. That is indeed it for the day. Yep. And guess what, kids? I'm not going to turn myself. We'll back that music down a little bit. No, I need to. Camera on. Ending screen here. Oh my God, what is that? That's not. What is oh? Oh, I know what. Actually, there we go. I don't know who that human was. That's the crazy guy in the background, looking nuts. Anyway, ladies and gentlemen, that's all we have for tonight. Elvis is still alive, and Wolfie did it. These are all true statements. And I do want to say thank you very much for hanging out with me. I thought the Simpson case was kind of out there. I had a feeling I knew what way it was going to go, because no matter how you cut it, even if things are fake to begin with, it's all illegal in the end. And it's not often we see judges actually campaigning for lawyers to forgive debts from defendants, and I thought that was kind of a feel-good case. And amongst all of the other crazy stuff, especially the hardcore Judge Middleton that we never get to see Middleton rule on. And man, that was a side of Middleton I don't think I've ever seen in all the time I've covered. Thank you all for being here, Northwest. Mama, Rhonda, Becky, Donald, Kat, Charlene, Romiticus, Moose Lodge, Rebecca. Thank you all very much. I've got to scroll to see other people's names. Here, I'm going to do this. Did I say Kiernoth? I think I said Kiernoth. I know I didn't say Straw Carpenter. Hello, Straw Carpenter. Becky, it's great to see you. Ray, great to see you. Felix, did I say your name? Kier, did I say your name? I'm no. This is not what I do. Ladies and gentlemen, all my lurkers, all my chatters, you are all wonderful. Thank you so much. And most especially, I do want to give a shout out to Mommy 2T. And Mommy, I think I think a comment was sent out to you earlier from I am low, and mom accidentally deleted the comment thinking she was deleting another comment because the chat was moving fast. Sorry about all that. Things happen. You know. Right? Thank you so much, Mom. You are all wonderful. I'm your lone wolf whistle, and I am out. And remember, most importantly, if you don't remember anything else from tonight, remember this. Don't sweat the petty stuff and don't pet the sweaty stuff.